na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Dig it up. Oh na 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 na. Dig it up. Oh na 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 na. Bam bam. Bir bam bam bir bam bir de. Bir bam bam. Bir bam bir de. Bir bam bam bir bam bam bir bam bir de. Bir bam bam. Bir bam bir bam 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 bam. Bir bam bir de. Bir bam bam.
Good day, everyone. Welcome to Home and Away Jamaica, where we connect Jamaica with the diaspora. It's good to be back again, and I'm Robert Taylor. With me today is special guest, maybe not special anymore. She's been with us quite a few times. Is Miss Stacey Salmon, managing partner at Taylor Law. Welcome, Stacey.
Thank you. Thanks again for having me.
So we normally invite and welcome Stacey when we have some very specific and detailed questions with particular areas of the law. Today we will be answering some questions that viewers have put forward to us. And so we're going to rely on Stacey's experience in providing some answers to these questions. So let's get right into it, Stacey. So one viewer has asked, how can one probate a will where there's a timeline that exists for probate?
All right. So an executor is required to probate a deceased will within 3 years of the death. So the executor has to make the application to the court for the grant of probate within 3 years. If it is that 3 years has elapsed from the passing of the deceased, what he'll have to do, or what the applicant will have to do, is to also prepare an affidavit of delay explaining the reason why the probate was not applied for within that 3-year period.
In your experience, Stacey, is it common that the probate process commences within that 3-year period?
It almost always I have to prepare an affidavit of delay. For most executors are not aware that the time limit exists. So, they don't really place much urgency on commencing that process.
Okay, so this viewer and viewers in general should not be overly concerned. The law does provide for an option to extend this timeline.
It does, and ignorance of the law is accepted as a reason for the delay in applying for the grant.
So that's one of the exceptions of
That's correct.
Of the law. Okay, good. So we have another question. What about land title fraud? We know that Jamaica has issues with fraud at the land titles division. How does a buyer protect themselves against this danger? So maybe we want to break this question up. It's saying, identifying that there is land title fraud. It's saying that we know that Jamaica has issues with fraud at the land titles division. Maybe you may want to speak to that, being a former employee of the land titles division. And how does a buyer protect themselves against this danger?
All right, so there have been instances of fraud. I'm just going to be upfront. There have been instances of fraud. The titles office, they have imposed certain policies, guidelines, procedures in order to prevent these instances from occurring. But unfortunately, from time to time, instances of fraud occur and things slip through the crack. However, an owner of a title holder, I should say, can protect their interest in the land by lodging a caveat on the property. So once a caveat is lodged on the property, no one can transfer their interest in the land, or no dealing will be registered at the titles office without first informing the caveator. So you as a registered owner, if you place a caveat on your title, it cannot be transferred without you first knowing.
So let's dissect this a little bit, Stacey, and look at some practical situations. So someone produces a duplicate certificate of title, and just to let our viewers know, the title you have is not the original title. The original title is kept with the registrar. What's issued to you is a duplicate. It's a mirror of what's with the registrar. So let's say someone replicates a duplicate and by fraudulent means takes steps to transfer what is someone else's property. Would the registrar not pick that up when that title comes in to be transferred?
Right. So I'm glad you brought that up. When any dealing or instrument, if a transfer is submitted, if a mortgage is submitted, any application that's submitted to the titles office, along with a duplicate title, the registrar will ensure that her original title that is kept in the vault at the titles office matches or mirrors the duplicate title that is submitted.
Are there instances too where the registrar herself may lodge a caveat on property to protect the paper title holder or unsuspecting purchasers that there is a fraud involved?
Right. So the Registration of Titles Act empowers the registrar to place a registrar's caveat on the title if she has suspicions of fraudulent activity in relation to a specific title.
Now let's explore a third instance, and this is one that came to mind when the viewer made this query about land fraud. It is not uncommon that in Jamaica you have parcels of land that are unattended for prolonged periods. And we have known of instances where persons prey on this land. They know that owners are overseas, may be deceased, family members may be unaware. Someone pays the property taxes and takes steps to acquire this land by adverse possession. And we've known of schemes where persons deliberately set about to identify and prey on this land. How can the paper title holders, persons who own and are the registered owners, protect themselves against this?
All right, so previously I mentioned the option of lodging a caveat on your title. So the first recommendation I would say is if it is that you are overseas and you have unattended property in Jamaica, it's very important to exercise your claim of ownership. And the strongest protection that you have available to you would be to lodge this caveat against your own title. It will prevent any third party from dealing with your title. Another recommendation would be to, put someone in it, have someone, whether a family member, you could lease it, just to ensure that no other third party claims an interest and extinguishes your right to ownership. Also, I would say to put up signs, no trespassing. Anything that you can do to assert that you are the owner of the property.
That you've not gone to sleep on your rights.
Exactly.
Last instance that I'm going to raise, and I'm going to ask you to explain. There are instances where title may be issued, not in a regular circumstances, but it's issued on paper that is produced by the registrar of titles. Explain how the curtain principle works and how purchasers are protected where they may be an unsuspecting purchaser and the type of reassurance they can expect from the registrar.
All right, so as we also mentioned before, the original title is, okay, let's rewind a bit. When a title is first issued, it's produced in duplicate. So the original title will be kept at the title's office. It does not leave the vault of the title's office. And the duplicate is issued to the registered owner. So if any transaction comes in for processing, the registrar pulls the original title to ensure that it mirrors the duplicate title that was issued. Now, the curtain principle, it basically states that you don't have to look behind what the face of the title states. So if it is that Robert Taylor is a registered owner, it's taken at face value. So no further investigations would have to be made if it is that you are registered as a title owner.
Okay, so you're saying then is that the registrar provides some kind of insurance, assurance, mitigation against fraud when titles are issued unsuspecting purchaser. If for some reason the registrar has issued a title that may have had some irregular circumstances resulting in its issuance, the registrar of titles will stand behind that title that was issued and protect that unsuspecting purchaser.
That is correct.
Okay, great. So I think we've exhausted that one. We've looked at a number of issues there. Third questions. Are licensees or tenants at will covered under the Rent Restriction Act? So maybe we can explain to our viewers the difference between a licensee and a tenant at will from your tenant.
All right, so a tenant, all right, we have to first, like you said, we have to first differentiate what a tenant is as opposed to a tenant at will as opposed to a licensee. Now, a tenant is someone who leases an interest in land from the landlord. And that's typically formalized by a lease agreement or a rental agreement. A tenant at will has been given the same leasehold interest, but that arrangement has not been reduced to writing. So a tenant at will has exclusive possession of the property and can exercise rights of a tenant. However, his relationship or his agreement is not in writing. A licensee, on the other hand, is someone who's given permission to occupy the land. So he does not have any rights of a tenant. He's simply given permission to occupy the space or occupy the home.
Would that be like a boarder, someone who's occupying on a short-term basis?
Exactly. So a family member, an employee who works on property. So there's no intention to create a legal relationship with this person.
Maybe even a visit to the movie theater. We could be licensees.
Exactly.
Okay. Now, which of these are covered under the Rent Restriction Act, and what would, if not, how would the law protect someone who's faced with issues by a licensee or a tenant at will?
All right, so the Rent Restriction Act sets out the rights of a tenant and the rights of a landlord. It governs that relationship. Now, the tenant and tenant at will, they have rights. They can exercise rights under the Rent Restriction Act. Because the licensee has not been conveyed an interest in the land, they're not deemed a tenant. They have no rights. Bluntly speaking, they have no rights under the Rent Restriction Act. And if it is that a licensor wants to evict a licensee, he simply has to verbally communicate this to him. He can say, I need you to leave my premises within 2 weeks or 30 days. A tenant, however, the landlord would have to follow certain steps under the Rent Restriction Act to legally evict a tenant.
Okay, so the tenant at will, or well, more specifically, the licensee just needs to revoke that permission.
Correct.
Okay, great. So we're going to wrap up with one more question. So it's fairly lengthy, but I'm going to summarize. So one of our viewers wanted to know, she basically wants to know her rights as a tenant. She's been living in a rented apartment for over 9 years, and she's concerned about the landlord's intervention in her ability to live peacefully in the circumstances. And a part of what is creating this conflict is that she's renting a part of a property and the landlord lives in another part of the property. So there's this constant overshadowing by the landlord. And one of the issues, and the main issue she has to confront with, is that the landlord is always interfering, taking actual presence in her property, pointing out that the property needs to be painted, fixtures need to be repaired, painting on the veranda, outside of the house. If her son soils the walls, then he's always stepping in and creating this urgency on her to carry out these repairs. The landscaping, for example, that's split between both. She doesn't have an issue, but then there is the view as to how often it should be cut. He may feel it needs to be cut twice per month. She may feel and can only afford to do it once per month. So she's in kind of a pickle because we have this very unusual situation where she's almost cohabiting, for want of a better word, with the landlord. How would you advise her, bearing in mind the limited information I've shared with you?
All right. Boy, there's a lot wrapped up into that one question. All right. So first and foremost, when you enter into a rental or lease agreement with a landlord, the landlord, under the Rent Restriction Act, the landlord is to give you quiet, peaceful, enjoyable possession of the property. Sure, in layman's terms, he's not to harass you. So if it is that the landlord is being unreasonable in terms of, entering upon the property without, without giving notice, not keeping the premises in a habitable condition, the tenant really should consider finding, alternate premises to relocate. But if it is that, she wants to stay on the property, I would say if whatever things need to be done, for example, if the inside needs to be painted, she can paint the property, paint the inside of the property and bill the landlord. If there tiles raising up, she can hire someone, have it remedied, and then, pass on the invoice to the landlord to be reimbursed.
Good point there, Stacey, because what struck me is the intermittent and frequent need for repairs. And one of the obligations of the tenant is to return the premises in the condition that it was delivered.
Right.
And so if it were painted, freshly painted, in a particular color, at the end of the tenancy, it would be the tenant's responsibility to return the property in that condition. Now, for practical purposes, children living in a home, walls are going to be messed up. I don't see where the tenant has an obligation to constantly be painting the walls until her tenancy is up. The issue, and as you raised, tiles being displaced and the responsibility of repairing those tiles, the lease should have in there some notation of the obligation of the landlord for repairs. And usually what we would do in many of our leases is put a limit on that cost. So we would probably say anything up to $10,000 or $5,000 is the responsibility of the tenant. Anything above that is the responsibility of the landlord. So maybe one of the things this tenant needs to do is have a lease in place. It would seem to me there's no written lease, and so she's in occupation under common law.
Right. She would be a tenant at will.
And she would be a tenant at will. So perhaps our advice to her is to insist on a lease and make sure that the lease has these terms so that they can be enforced. Like you, my first reaction was maybe she needs to find somewhere else, somewhere that she's free of the tenants, the landlords overshadowing, but it could be that the rent is fairly reasonable and there are other circumstances that would make it difficult for her. But certainly we're agreeing that perhaps she should have a formal lease agreement put in place.
Right. Anyone leasing property should insist on setting out the terms of that rental agreement. It's very important.
Well, Stacy, thanks again. Always happy to have you and appreciate your input. But I think there's one quick question. What if the landlord refuses to reimburse the costs or provide an agreement?
All right, if it is that the landlord refuses to reimburse the cost, the proper way to recover that cost would be to seek recourse through the courts. It's not an option to withhold the rent.
Or deduct from the rent.
Exactly.
Okay. Oh, and what happens if he refuses to provide an agreement?
If he refuses to provide an agreement, if I were in her position, I would get an agreement, provide it to him, have him review it, sign. If it is that he doesn't want to, I guess, incur costs or put out that effort to create an agreement, but it would be in my best interest as a tenant to have a lease in place.
Would the rent board be one option of recourse, a complaint?
Yes, the rent board is always available to the tenant.
Okay, great. Thanks again, Stacy. I think we've scoured that question. Thanks for your input, and thanks to our viewers for sending in questions. We encourage you to continue to send questions in. It makes our outreach a lot more practical when we can address issues that are, confront you on an ongoing basis. So thanks again, Stacy. Bye for now. And until next time from us here at Home and Away Jamaica, your host, Robert Taylor.
Bam, bam.